Man took leaf blower, not burglary. So man takes leaf blower. So brazenly, it wasn't burglary. The Supreme Court of Ohio unanimously decided that Donald Bertram did not use, quote, force, stealth, or deception to commit his burglary. Therefore, it's not burglary. He should instead be convicted of a lesser offense, misdemeanor criminal trespassing. According to court documents, a homeowner was working on his property in September of 2020 when he heard the loud muffler of a passing car. He went inside the house to get his cell phone, and when he came back outside, he made eye contact with the driver of the car, Bertram. Bertram drove past the home but then turned around and parked on the road near the driveway, walked up the driveway, smiled at the homeowner, acted very cavalier but with no sense of urgency, walked into the garage, took the leaf blower, and walked back to his car. Bertram ignored the homeowner's demand to put down the leaf blower and instead put it on the passenger seat of his car and attempted to drive off. The car didn't immediately start. The homeowner took several close-up photos, and Bertram eventually drove away. He was soon arrested and convicted of burglary, but he appealed the jury's verdict. The Court of Appeals affirmed the decision, so it went to the Ohio State Supreme Court. Justice Michael Donnelly, writing for the court, noted that the lower courts determined Bertram engaged in stealth and deception. So this must be a consequence of the definition of Ohio's burglary statute. That burglary requires, in addition to, what we traditionally think of as burglary, the taking of something that doesn't belong to you, that the burglar must be engaged in secret, sly, or clandestine conduct. And this openness of being brazen about it, walking right past the homeowner and taking the leaf blower right in front of the homeowner from the homeowner's garage, while a crime does not meet the Ohio crime of burglary. Now, the usual myth I hear about burglary is that you don't commit burglary if you don't break and enter. If you don't break something and you instead just enter, then that's not burglary. Well, that's certainly a fun thought exercise, but what we're talking about is breaking the virtual or theoretical property line of the building or home. Breaking the close. It used to be called the close of the door. CLOSE, like closing a door. So you close the door, right? So that's the close of the house. You break that sort of virtual closed door barrier. Even if you did it through an open door, or you opened a door without breaking anything, or crawled through a window or a duct or something and nothing was harmed, it's still burglary because you have broken the close, or otherwise broken the virtual barrier of the thing. This is a new one. That you can't engage in burglary in Ohio unless you are also engaged in secret, sly, or clandestine conduct. The court vacated Bertram's 8 to 12-year prison sentence. They vacated a 491-day sentence for violating probation, and they noted a prison term for violation of probation can only be imposed for a felony, and in this case, that matter was vacated. No longer a felony, now just a misdemeanor. So I guess, I don't know, does he have a case for now being in prison for too long since they convicted him of something he shouldn't have been able to have been convicted of? So the people of Ohio will probably have to answer for that as well. Frankly, I would have made the same mistake, I think. I would have assumed that the burglary statute would have applied to this situation, even if it was done openly. But that openness of it seemed to have changed the outcome in that one. So that's an interesting one. Let me know what you think in the comments below. Isn't that simple theft? Yeah, it's probably some kind of misdemeanor theft, or what did they say up here? It should have been misdemeanor trespassing. I'm not entirely sure why it's not something more than trespassing. Just because you're allowed to use reasonable force to prevent the theft of your property doesn't mean you have to. I don't think the insurance company is going to tell me I was supposed to resist the guy, get myself hurt or something like that. I don't know. I mean, I can hear an American insurance company saying it, but we're trying to think cleanly here. Yeah, how is it not some kind of theft or conversion? It probably also is some kind of theft or conversion. And in this case, they just overcharged. So anyway, yes, let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney. This is Lawful Masses, your favorite legal news and education program, here on twitch.tv/lawfulmasses on Sunday mornings, 10 a.m. Eastern U.S. time. And if I can figure out how to operate my computer, I can get to my May. Thank you very much in the month of May to Evie, Ugly Grill, Torpedon, Pure Magma, Eric Tams, Tech Potato, Good Broge, King Aries, The Blood Soaked Survivors, Kyle Seafring, and don't credit or shout out this account. I love you guys. Have a good week. I'll see you in the videos that drop. Bye.